Morning, everyone. Hello and welcome to Mayorbank's License to Kill, Administrative Patent Invalidity Proceeding in the U.S. and China webinar. My name is Jing Zhang, and I'm partner in Mayorbank's Washington, D.C. office and a member of the firm's Government and Global Trade Group. I'm actually the moderator for today's webinar. Allow me briefly introduce our three speakers today. First, we have Mr. Gary Knapp, who is a senior IP partner of Mayorbank. Gary has been a patent attorney for several decades, a very experienced IP litigator. Also joining us today is Mayorbank's Mr. Brian Macy, a senior associate of our IP group, who has worked on many IPR matters and would like to share his view with you today. Lastly, we have our guest speaker today, Mr. Mao Jin. Mr. Mao is a partner at the law firm of King & Wood. Before joining King & Wood in 2011, he sat on China's Patent Review Board for more than 5 years. Before we begin today, we'd like to mention a few housekeeping announcements. First, please note that when accessing Mayorbank's webinars via our On24 platform, we suggest avoiding use of desktop visualization software such as Citrix to decrease disruption and quality loss. Secondly, as listed under the FAQ widget on the right side of your screen, today's program is being streamed through your computer, so there's no dial-in number. For best audio quality, please make sure your computer speakers or your headphones are turned on and the volume is up, so you can hear the presentation. If you have any questions that are unanswered during the presentation, I invite you to submit them using the Q&A feature on the right side of your screen. And we will do our best to the best of our ability to follow up with you directly after the webinar has ended. Regarding the CLE credit, and I understand this is important, we'll be providing an alphanumerical code during the presentation. In order to receive CLE credit, participants must record this code on the virtual sign-in sheet that was emailed to you with the login instructions for today's program. These forms are also available to download on the right-hand side of your screen and the resource list if you need them. With that said, and without further ado, let's get started. First, I will turn it over to Mr. Mao for the Chinese portion.
Okay, so Jing, it's my turn?
Yes.
Yeah, okay. Hello, everyone. Thanks for Jim's invitation, and maybe I can just give some introduction to the Chinese invalidation proceeding. I've worked in the PRB. We name it PRB. That is the division, government division, handling the invalidation proceeding. And I worked there for 5 years, and right now I'm handling maybe more than 200 invalidation cases. After I depart from that department. And maybe we can, Jim, could you present the slide of page 5? So that is, I think that is the major proceeding of the Chinese invalidation procedure. And in China, anyone can file the invalidation request. The patent office do not mind if you are the infringer, accused infringer, or other person or strawman. They don't mind that. So we do not need to worry about the reputation issues. And anyone who files the invalidation request can give any prior art or not, even just for the formality issues and grounds, and it's possible to invalidate the patent. And after the petitioner files the invalidation request, he has 1 month to present the supplemental statement or supplemental invalidation request. And the PRB will combine the original petition and the original invalidation request with the supplemental invalidation request together as a whole one, and transfer all the documents to the patentee. and the patentee, after receiving the documents, and the patentee can amend the claim within 1 month. And this is very different with US and with Europe. And because in China, the patentee just have this chance to amend the claim. And this is very important because for some of the invalidation procedure, the key issue to win the case is how to amend the claim. And I will introduce that to you later. And the patentee can amend the claim within 1 month after receiving the transferred invalidation request. And at the same time, with this time window, the patentee can also submit some evidence to prove that the petitioner's invalidation ground is not persuasive, or he can prove that the argument from the patentee's side is totally wrong. So at this time window, and the patentee can do at least three things. One is amend the claim. The second one is submit some evidence to rebuttal the invalidation request. And the third is submit some opinion or observation to maybe to present his idea and to argue why this patent should be deemed as validated. And PRB will transfer the patentee's amended claim and evidence or observation to the petitioner again. And after that, within 1 month after the petitioner receives the papers, within 1 month, the petitioner can adjust its invalidation ground and can submit some rebuttal evidence against the patentee's evidence. But at this point, the petitioner cannot provide new prior art evidence. So all the prior art to attack the claim, even if the patentee amends the claim, all the prior art should be the first stage that the petitioner submit to invalidate the claim. So this means at this point, even though the petitioner can submit some rebuttal evidence, but he cannot submit some new prior art. And after that, maybe this is the whole proceeding before the oral hearing. And after all this has finished, maybe 2 or 3 months later, the PRB will hold an oral hearing. And the whole oral hearing, some of the oral hearing just last for half of the day. And some of the cases that will last for 1 day, but it's very rare and seldom that lasts for more than 1 day. So the time is very precious because you need the petitioner should express all his opinion, all the prior arts, and all the combination within that 1 day. And in the oral hearing, the PRB will ask the two sides to cross-examine the evidence, to do some claim construction, and to prevent the disclosure of the prior arts, and to do the mapping between the claim with the prior arts. And after the oral hearing, for most of the time, the PRB examiner, they would not accept any new submitted material, including your statement or opinion. They will reject to receive anything, any material. So you need to present all your opinion in the oral hearing. And after the oral hearing, it takes, most of the time, it will take 2 or 3 months. And after 2 or 3 months, the PRB will issue an invalidation decision. This is a normal time, but for the complicated cases that would last after the oral hearing, it would maybe take more than half a year to issue the PRB decision. So this is the whole proceeding for the invalidation proceeding in China. And after that, anyone who are who is not in favor of the decision can appeal to court, and the appeal will be accepted by the Beijing IP court. And that is the first instance of administrative litigation. And the second instance of administrative litigation is the Supreme Court. So it's very easy in China for the case to go to the Supreme case. And this is the whole proceeding. And I can give you some numbers. First, that is in China last year, there are around 4,000 invalidation cases. And within that 4,000 cases, 40 of the cases was declared invalidated. So it's a very high number that maybe the ratio of the invalidation is very high. And after the administrative litigation, 15 of the PRB decision will be revoked by the court system. So this is the basic situation. And maybe next slide. In the invalidation proceeding, normally it can include some publications. So this is normal. But in China, the prior use evidence is very, very strict. For most of the time, in US, and the prior use can be existed or can be established. But in China, you can't, because PRB and the court system require a very, very strict standard of evidence. And so for example, the witness in US system is accepted. Maybe a deposition is enough to prove that some kind of product has been sold in the market. But in China, that would not be accepted for most of the time, because PRB believe that any witness invited by any party may be lie to the hearing, or maybe for most of the time they don't believe that they are honest to express clearly. So we need to be careful that the prior art use or prior art sales is very strict, and the ratio to invalidate a case using the prior use evidence in China is very, very rare. Next slide. And the result of invalidation decision it really influence to the infringed case. Even though anyone who is not in favor of the decision can appeal to the court system, but the infringing court, the court who handling the infringing case, will dismiss the case when he knows that your patent was declared by PRB that is invalidated. Because the administrative litigation in China will last for a very long time. It usually costs more than 2 or 3 years. So the court who handling the infringing cases will not wait for such a long time. So anytime your patent was declared invalidated in PRB, and the court will dismiss the infringing case immediately. And while your patent was maybe while the PRB decision was revoked by the court, this means and your patent was maintained validated at last. At that time, and you have the right to sue the accused, maybe the accused infringer again. So you can do that again, but at the first proceeding of the infringing case, your case will be dismissed. Next slide. And I can maybe introduce some key issues in PRB. The first one is the amount of claim. So that is a very important issue. Next slide. Because for most of the time, when the patent was issued, the protection scope is very wide, and we cannot in the prosecution stage, the examiner will not find all the prior acts, and in the invalidation proceeding, because the petitioner will use lot of power and using lot of means to find and retrieve the prior acts. So it's very easy. He can find that some prior acts fall into the protection scope of the patent. So it's very important to amend the claim. But in China, just as I told you, you have just one chance to amend the claim. That is after you receive after the patentee received the whole invalidation request. Within that month, within the time window of 1 month, you can do the amendment. And if your amendment is not accepted by the PRB, he will not tell you at that stage. And while in oral hearing, most of the time, just in the oral hearing, the PRB will told you that your amendment cannot be accepted. And at that stage, you would have no chance to amend your claim again. So in China, you just have one chance to do the amendment, and if your amendment is accepted or not, can just be, as a result, can appear just in the oral hearing. And at that time, if your amendment cannot be accepted, the examination of the patent would just target as the issued patent. So you don't have you will lose the right to amend that. And how to amend that is the last one, the last slide. That is, in China, we cannot pick up some elements of the specification into the claim. And we cannot, if we do not amend the independent claim, and we cannot just amend the dependent claim. And it's also that we cannot just add part of the element of the claim, part of the elements of other claim into the independent claim or dependent claim. So I will give an example that is very maybe specific about it. So we can see this is several kinds of the claims, and we can see that claim 1 and claim 2 are the cell phone, claim 3 and 4 the communication process. And we can see claim 4 is very special because in claim 4 there is a technical feature that is C, and the C is the C includes C1 and C2. C1 and C2 combine together as an element. So in this situation, you can just add C, maybe the C in claim 4 into claim 1, but you cannot add C1 in claim 1 because the PRB will deem that this is just a partial of the element, not the total element. So for these examples, we can see that in China, they have a very, very specific rule about how to amend the claim. And if you lose the if the amend of the claim cannot be accepted, and you don't have any chance to amend the claim again. Next slide. Another key issue in the proceeding is estoppel, and because in most of the time, the main purpose is to kill the patent. in the invalidation procedure. But sometimes, if we cannot kill the patent, we need to use maybe use the observation of the patentee to limit the protection scope of the claim. And how to limit the protection scope, that is the most important, is depending on the claim construction of the patentee. And so what the patentee said in the oral hearing can be used to limit the protection scope of the claims in the infringing cases. But in China, there are some difficulty in practice. First is that only the I think the PRB the record of the hearing in PRB is not so good as the US, because typing English is more easy, but typing Chinese words is very slow. So in most of the case, the examiner can just record part of what you say or the main idea of what you say. So this means you will lot of information by what the patentee said will be missed from the paper record, and only the paper record can be kept and preserved and transferred as evidence in the infringing court system. And so, and the video record is just kept inside the PRB, and you cannot access to the video record. So this means if you believe if you believe something the patentee said is very important for you to using as a staple, you need to remind the examiner to record that in the paper, or else that would be missed. And this is the first issue. And the second issue in the estoppel is that only what the patentee said has been used in the invalidation decision as a basis to maintain the patent as validated. And only in this situation, what the patentee said can be used as a estoppel in the infringement court system. So this means if the PRB examiner do not accept the patentee's opinion, or do not use the patentee's opinion to maintain as the basis to maintain the patent valid, so that means that cannot be the estoppel as well. Next slide. And the third important key issue is how to define the disclosure of the prior art. In the Chinese invalidation proceeding, we do not have any limitation for how many pieces of the prior art should be submitted, and we do not have any limitation of how to combine these different prior art. So the petitioner have a right to submit the prior art as much as possible. But sometimes, for most of the time, this is not a good choice for the patentee, I think, because in some of the oral hearing, because they just held the oral hearing for 1 day, so the time is very precious, and the examiner always asks you to choose the best combination from the petitioner's side, and the panel just give you one chance to present the best combination. And if the the prior art and the combination you present as the best one is not persuasive and is not accepted by the PRB examiner, and the panel will believe that in most of the time that other combination or other prior art is weaker than the first one you present. And even though it's their job to read all the prior art, but for sometimes they will just miss some very important information, and maybe for most of the time, this means it's very likely that you will fail in the invalidation procedure. So just pick the best one and present the best one. Next slide. And for the prior art cited in the invalidation proceeding, there is a very common issue that is sometimes because just the technical means will be recited in the claim, and the technical effects will not be cited in the claim for most of the time. And sometimes the prior art disclose all the technical means of the claim, but maybe the technical means or the technical solution in the prior art is not used to solve the problem of your patent. The technical problem disclosed in the prior art is totally different, and the technical effect is totally different. But while you compare the claim feature with the technical solution or technical means in the prior art, you will find they are totally the same. So will this be deemed as the disclosure of the claim? Right now, I think the PRB will not think so, but maybe just 2 or 3 years ago, they just compare the technical means, and they will not consider if all the technical means is the same, they will not consider about the technical questions and the technical effect. But right now, they have issued some kind of decisions. That is, even though all the technical means is the same, but if the technical problem and the technical effect is not the same, and this is not be deemed as the disclosure of the claim. I will give an example. Next slide. So from this picture, we can see that the next one is the patent, the right one is the prior art. We can see that both of these are used in the LCD panel, and both of these two solutions, they have a slot. So, and the claim just recites the technical feature of the slot. And in the patent, the technical effect is to the slot in the patent is used to maybe to contain some bubble in the liquid crystal. But in the prior art, they have the same slot. Just it's also in the LCD panel. It's also in the slot in the surround the panel. But the slot is used to maybe to delay the flow of liquid crystal. So the next one, the slot is used to maintain the bubble in the liquid crystal. And the right one, the slot is used to delay the flowing of liquid crystal. So they are facing different technical questions, and the technical effect is totally different, but they have the same technical means. And the PRB decision, this is a real case. The PRB decision said that even though all the technical means was disclosed by the prior art, but because the technical problem and the technical effect is totally different, so the prior art cannot disclose the claim. So the patent is made as valid. Maybe this is my presentation. Thank you, Jim.
Thank you, Mr. Mao. So we're turning to the U.S. portion of today's presentation. Gary?
Good. Good evening, everybody. Good morning from the United States. Again, my name is Gary Knapp. I'm a partner in Mayor Brown's Washington, D.C. office, and it's a real pleasure to have an opportunity to speak with you today. Next, we're going to cover inter partes review proceedings at the United States Patent and Trademark Office. So the theme of this presentation is license to kill, and we're going to be discussing how you can use this procedure to kill a U.S. patent. So in our brief half hour, we're going to discuss what is an IPR, or an inter partes review proceeding. How do you request one? When can you file an IPR? When should you file an IPR? Because you have options and choices, and there may be reasons to file one sooner or later. What is a typical IPR timeline? What is the basic process? Why might you want to file an IPR? And we'll be covering some recent developments in IPR proceedings. And I found Mr. Mao's presentation very, very interesting. And I think what you're going to hear is that there are some similarities between the United States and the procedures in China, but there are also many, many important differences between the two systems. So first, what is an IPR? So this is a procedure that actually began on September 16, 2012 through legislation in the United States. So I'd like to wish a happy birthday to IPRs. They've been going for 8 years now. And it was a significant development. And it was something that was enacted in order to try to streamline the procedures by which patents could be invalidated through proceedings at the Patent and Trademark Office, but at the same time protect patent owners by giving them some protection against having multiple attacks on their patents, both at the PTO and in district court proceedings. We'll be talking about that a little bit later. But in essence, an IPR is a trial-like discretionary proceeding at the PTO, which means that it's like a trial, but there are definite differences between that and a trial in a court in the United States. It allows anybody to challenge the claims of a patent. So just like in China, both patent owners and patent challengers can use IPR proceedings if they wish. They are generally used to challenge the claims of a patent as being anticipated or not new or obvious. And they're decided by a panel of 3 administrative patent judges. And one significant aspect of these is that you are having the case decided by patent judges who generally have technical backgrounds and understand the technology. So what can you argue in an IPR? Well, in an IPR, what you can argue is that the patent is invalid because of anticipation or obviousness. Anticipation means you can find all of the elements of a claim in one reference. Obviousness means you combine typically more than one prior art reference to arrive at the patent claim. And so what you can cite are patents and articles and books and so forth. Different from China, you can also argue some other things, but what you cannot argue is that the patent is indefinite or that the subject matter is ineligible under 101, that it's not patentable subject matter, or that the patent claims are unenforceable. So from September 2012 through at least July 2020, and these statistics come from the website of the Patent and Trademark Office, there have been a large number of IPR proceedings that have been filed. And in about 33% of them, about 1/3, the Patent Office actually chose not to institute an IPR. So in a fair number of cases, and we'll go through the procedure in a minute, the Patent Office simply decides not to go forward after the filing of a petition. But once you get over that institution hump, in a large number of cases, the patent claims are invalidated, either in whole or in part. So In 33% of the cases, institution was simply denied. In 29% of the cases, the parties settled during the process. And in the rest, in most of the rest, the patent claims, either one claim or all the claims were found to be unpatentable. So the institution threshold is a very important point in an IPR proceeding. So how do you request an IPR? If you think a patent's invalid and you want to utilize this procedure, how does it work? Well, it begins with the filing of a petition with the U.S. Patent and Trademark Office. And that petition has to include, number one, detailed invalidity arguments. Often claim charts are included. But you have to lay out your prior art arguments in your initial petition. Unlike the procedure that Mr. Mao described, where there's a second kind of submission after the initial one, with an IPR, everything has to be in the first petition. So if you don't include prior art, if you don't include arguments in the initial petition, you're not going to be able to make them later. And that means that you have to prepare your initial submission very carefully. You have to explain how the claim should be interpreted with respect to any claim construction issues that you want to raise. And now the PTO uses the same standard as U.S. district courts. It used to be that the PTO used a much broader standard, but now they use the same standard for claim interpretation as in a district court case. You have to state what the names of the real parties in interest. So an entity cannot simply file an IPR on behalf of another company and keep the other company's name secret. The PTO needs to know who the real parties in interest are, who you're really filing the petition on behalf of. You have to identify lead and backup counsel, individuals who are registered to practice at the PTO. And importantly, you're limited in terms of the number of words, no more than 14,000 words. And that may seem like a lot of words, but when you have patents with a lot of claims that you want to attack, and you want to use multiple prior art references or arguments, you're going to find that very quickly you're going to be limited in terms of the arguments you can make by the word limit. So as Brian will be discussing a little bit later, it's important to put your best arguments in the initial petition and to consider limiting the number of arguments that you make. You should strongly consider including an expert declaration with your initial petition. In most cases, the petitioner will support the petition with an expert declaration. If you don't put in the expert declaration, you may be limited in terms of your ability to put one in later on. And if instituted, the IPR must be instituted on all grounds. And so that when the PTO decides whether or not to go forward with the IPR, they can't say, well, we're going to go forward on this ground number one, but the other three grounds we're not going to go forward in. They have to either go with all of them or none of them. And that's as a result of some recent decisions in the courts in the United States. So when can you file an IPR? You can file an IPR 9 months after the issuance of the patent, or if there is a post-grant review proceeding for patents after March 16, 2013, after the termination of such a proceeding, or within 1 year after service of a complaint for patent infringement, which means, number one, you have to wait 9 months after the patent issues before filing an IPR. If you want to file it sooner, you can use another procedure called a post-grant review procedure, which we could discuss if we had more time, but time is limited, so we'll leave that to another subject. But also, if you're sued in district court, you can't wait forever to file an IPR to challenge a patent. You have to do it within 1 year after you're served with the complaint for infringement in the district court. And interestingly, there's a procedure in district court where if you want to challenge a patent, you can file what's called a declaratory judgment action. In other words, you affirmatively ask the court to declare that a patent is not infringed or invalid. But if you do file one of those declaratory judgment actions in district court, you cannot then also file an IPR claiming the patent's invalid. You don't get two bites at the apple under those circumstances. But if you're sued in district court, if someone else sues your company, then you can file an IPR and argue invalidity, still argue invalidity as a defense in district court. But as we'll be discussing later, there are limits to how much overlap there can be. Okay, so again, when should you file an IPR? Okay, we've said, you know, the outer limits of filing one, but when should you file one? Well, in a district court case, if you are sued in district court, you should consider filing an IPR as quickly as possible. The chances are that the reason is that if you file the IPR quickly, and especially if the Patent Office institutes, then there's a good chance, it's not guaranteed, but there's a good chance that the district court will put the case on hold or stay the case and wait to see what happens in the IPR proceeding. But if you're in the ITC, in cases called Section 337 cases, where infringement is being alleged, and you're named as a respondent, then you're going to want to carefully consider whether to file an IPR and when you should file one. On the one hand, just like in a district court, early filing may put the patent owners may put pressure on the patent owners to settle the case. And ultimately, if there is an order against you at the ITC, you may be able to use the IPR result to say the patent's invalid. But unlike district court, the ITC is unlikely to stay or suspend the case, which means the ITC case is going to go forward. And very quickly, discovery is going to be produced. The parties are going to develop their arguments, and you're going to find out very quickly, and the patent owner will find out quickly what your arguments are, and they may use that in making submissions to try and cause the IPR not to get instituted. So you have to figure out very carefully the pros and cons of moving early if you're sued in the ITC. Okay, so what is the basic procedure in an IPR? This will give you some sense for the timeline. So the first step is that a petition is filed, and then the patent owner has the option of filing a preliminary response, and often they will. The petitioner can reply to that response, and then the patent office will decide whether or not to institute the case. And that all takes place within roughly a 6-month time frame. And at that point, the Patent and Trademark Office will say either we're instituting and we're going forward with the IPR and we'll have a trial, or they'll say no institution, and then it's done. You're done at the Patent and Trademark Office. If the PTO decides to institute, then there will be a period for discovery where the patent owner can take discovery of the petitioner, but it's going to be very, very limited. Unlike district court, where you have lots of discovery and you have lots of document requests and you have depositions and both sides have lots of ways to get a great deal of information from the other side, which can take months and months and months and months. In an IPR proceeding, the discovery will be very limited to what the parties actually submit as evidence in their petitions. After that, the petitioner can take discovery of the patent owner's evidence. And again, we're basically usually talking about just maybe a deposition of the experts who submit declarations in support of the documents, or other witnesses who may submit declarations in support of the IPR. During that period of time, the patent owner has the ability to amend, similar to China, but there are some differences in the procedures as well. The patent owner can amend its claims during the IPR, and if they do so, then the petitioner can oppose a motion to amend as well as reply in support of their initial petition. If there is a motion to amend or an MTA, then the patent owner can come back and submit a reply. And then after that's all done, you have a hearing at the Patent and Trademark Office. And similar to what Mr. Mao described, these hearings are typically maybe 2 or 3 hours, maybe half a day. You don't generally call witnesses. It's really an opportunity for each side to present the arguments that have been presented in the papers and to answer questions that the 3-member panel may have about the case, and to submit arguments in support of their petitions. Then after that, there's a final written decision by the board in terms of whether they will support the IPR or find the patent to be patentable. And all of that will take place typically in 12 months. So from the institution decision to the final written decision is a 12-month period. And that, in a snapshot, is how these work. I think, as you can see, there are differences in terms of timing, the length of the procedure, and other important differences between the practice in China and the United States. And with that, I will turn it over to my colleague, Brian Nacy.
Hello, everyone. Good morning for those in the U.S. and good evening for those in Europe and in Asia. Thank you for joining us today. My name is Brian Nacy, and I have had an interest in IPRs almost since they first came about back in 2012. At my prior law firm, I helped them work on the very first IPR petition that the firm had prepared for one of our clients. It was a new procedure at the time, and a lot of folks didn't want to take the risk of getting it wrong. But I was a younger lawyer then and really jumped at the opportunity, and since then have been very interested in these proceedings and really tried to keep abreast of what's going on. And there have been a lot of really exciting, very recent developments that I look forward to sharing with you in just a few minutes. But first, I think it's important to consider and talk about how to determine whether filing an IPR might be right for your situation. And I'd like to talk about some of the benefits and some of the potential drawbacks. There are many of these, of course, and we don't have time to get into all of them today, but I want to highlight for you some of what I believe to be the most important ones. First of all, the benefits of IPRs, we can't deny that they're quite fast. 18 months may sound like a long time to many of you, but in the world of patent law, that is a pretty speedy way to get a final decision on validity. So that is something that I think is a big benefit. Also, equally important is the fact that you have this panel of 3 very knowledgeable judges in the field of patent law. Not only are they well-trained and well-versed in patent issues, many of them have technical degrees or come from technical backgrounds, and many of them were former patent litigators themselves, and so they really understand both sides of the coin here. They understand the technical aspects as well as the legal issues. Another thing that's a benefit of IPRs is that there is a lower burden of proof for proving invalidity. In a district court proceeding or at the ITC in the U.S., you would need to show invalidity by clear and convincing evidence. It's a rather high burden. However, at the patent office, to show unpatentability, you only need to do this by a preponderance of the evidence. Basically, it has to be just slightly more than 50-50 in your favor, and you will be able to invalidate the patent. That's a much more favorable burden of proof than you would have in other proceedings in the U.S. IPRs aren't perfect, however. There are some drawbacks. One of the biggest ones is that there is almost never any live witness testimony. The judges at the PTAB are very busy, and they simply don't want to hear it. They will look at the deposition transcripts very carefully, in my experience, and they will read the declarations by witnesses very carefully. However, they often just don't feel like they need to have a witness live and in front of them. So if you really want to tell a great story, if you really feel like that's something important here, an IPR will probably not give you the opportunity to do that. Another drawback is that the PTO cannot make determinations about infringement. So if you're looking for a one-stop shop for having someone decide whether the patent is invalid and whether perhaps one of your products infringes, if you'd like to do that in the same proceeding and tell that same story holistically, an IPR is probably not for you. It's not going to allow you to do that. Also, this last drawback could be kind of a benefit depending on how you look at it. There's very limited discovery in IPRs. As Mr. Nath just mentioned, primarily the discovery is just going to be deposing the other side's witnesses that have submitted declarations. There are procedures for obtaining additional discovery, and you technically can serve interrogatories and requests for production just like you would do in a district court proceeding in the U.S., but these are very rare and you actually need to seek permission from the board to do so. So you're very restricted in the discovery that you can take in IPRs. This could be seen as a benefit because it actually makes IPR proceedings a lot cheaper. You don't have to spend hundreds of thousands of dollars on discovery disputes and reviewing documents. It's a much more streamlined way of doing things. Another important point to mention when considering whether to file an IPR is estoppel. Estoppel essentially means that you are not allowed to make any arguments that you made in an IPR or could have made in an IPR after you get a final written decision from the board. And this is important. This was something that was very hotly debated when the America Invents Act law was being kicked around United States Congress. This was something that people really felt strongly about on both sides of the aisle. And ultimately, this estoppel provision to IPRs was a compromise in showing that if a patent owner does manage to get a final written decision and a determination that their patent is valid after going through this IPR procedure, they shouldn't be subject to the same attacks by the same party in district court all over again. IPRs inherently are meant to be an efficient and effective alternative to deciding the validity of a patent in a district court. And the estoppel provision helps ensure that. It helps ensure that we're not going to have to litigate the same exact issues between the same parties in two different forums. And so estoppel will apply not just to the petitioner and the real parties and interests, in other words, whoever is actually footing the bill and pulling the strings, so to speak, behind the IPR. It's also anyone that's in privity with the petitioner, and this can include parties that are subject to joint defense agreements or indemnification agreements. There's a lot of really interesting case law there, and it's a very fact-specific issue that needs to be looked into. Estoppel has its limits, though. It's not going to prevent you from arguing invalidity entirely in a subsequent proceeding. Any argument that you could not have made in IPR is going to be fair game. So 101 arguments for subject matter eligibility, 112 issues for indefiniteness of a patent claim, those are all fair game because you can't make those arguments in an IPR. Another important area that's off limits from estoppel is the use of prior art products and systems for arguing invalidity. Remember that Mr. Nath told you that IPRs must be based on printed publications. So I couldn't say that I have, for example, a prior art camera that invalidates a camera patent in an IPR. Similarly, I'm not going to be stopped from making that argument later on in a district court or an ITC proceeding. I want to now talk about a few recent developments in IPRs. There are many, and I wish I had 2 hours to go over them all with you, but I only have a few more minutes, and I'd like to highlight some of the ones that I think are most interesting, starting with the Precedential Opinion Panel, or the POP, that has been recently instituted at the USPTO. The POP was formed in September 2018, so about 6 years into IPR's history, and it came about out of concerns for efficiency among the judges in the PTAB board who decide IPRs. There are over 100 of these judges, and in the first several years of IPRs, there was a lot of inconsistency among those judges. There was very little binding case law to guide them, and a lot of these panels were doing things that were drastically different, and people felt that there was a lot of uncertainty about what to expect. So in order to address those concerns, this POP panel was formed that's by default going to consist of the director of the U.S. Patent and Trademark Office and the chief patent judge, and they are in charge of looking at decisions and deciding which ones should be precedential or which ones should be binding on future decisions by the board. Recently, parties have started actually requesting that the precedential opinion panel either take note of a decision that's particularly important to make it precedential, or to look at decisions that in some folks' view are outliers and that are going against precedential decisions. And in several of my cases, we've actually contacted this division of the board to let them know that, hey, this decision is against board precedent. We think this is an issue. We think that this is something that the precedential opinion panel should take note of. And it's another way to give a check and some guidance on what's happening. Another interesting recent development, in my view, are discretionary denials. In the past year or two, there have been a lot of interesting cases coming out of the Patent and Trademark Office Patent Trial and Appeal Board on this issue. Remember that Mr. Nath told you that IPRs are discretionary. There's no right to have one. The board can decide to institute or decide not to, and there's really nothing one can do about that. So there are really two avenues to these discretionary denials. There's this Section 314A, which is a section of the United States Code that governs IPR institution, and it makes clear that they are, in fact, discretionary. And so there are a whole host of reasons that patent owners have come up with for why the PTAB should use that discretion to deny institution. Two examples here in Section 314A would be when there are subsequent petitions challenging the same patent. Sometimes we call those follow-on petitions. And it's also used when it would be inefficient for the board to consider invalidity of the patent. Remember again that IPRs are meant to be this efficient and effective alternative to litigation. So if it's not serving that efficiency purpose, the argument goes, we shouldn't institute an IPR. An example of this would be if I'm about to have a trial on the validity of a patent in a few months, why would I institute an IPR proceeding now when it would take more than a year if I'm already going to be litigating these issues elsewhere? The second path to discretionary denial is Section 325D. And this is another provision of the United States Code that governs IPRs. And it essentially says that if the office, the patent office, has previously considered the same arguments or the same art, or if they're very similar arguments or very similar art, then the board need not institute review there. Again, there are a lot of interesting developments in this area, and I just briefly want to touch on a few. For follow-on petitions, the precedential case that sort of guides everything is known as General Plastic, and it set forth 7 or 8 different factors for when a subsequent petition should be denied based on the board's discretion. And you would consider things like the timing of the new petition, whether the petitioner had access to the patent owner's arguments in a preliminary response, or the board's guidance in an institution decision, as well as some other things, just to see whether it would be fair to subject the patent owner to these multiple repeated challenges by different parties for the same patent. In the branch of Section 314A denial that governs efficiency, 2 recent cases of note are the Apple v. FinTev decision. That came about in March of this year, and it was designated as precedential in May of this year, and a decision called NHK that was decided in 2018, and that was sort of the fountainhead case that started it all. Here, the efficiency factors you would consider are things like whether there's a trial date very close coming up, whether the district court has invested a lot of resources and time in the case, for example, by issuing claim constructions, and whether there's a significant overlap of issues, for example, whether the same prior art or the same arguments are being made in both places. For Section 325D denial, the board will look to see whether there are the same arguments being made, and if there are, it will ask, did the petitioner explain why the office made a mistake in considering those arguments before? And generally speaking, if the petitioner is not able to do that, then the petition will be denied based on this Section 325 discretion. And the case that governs that, another precedential decision from earlier this year, is the Advanced Bionics case that lays out these factors and lays out basically this two-part test to determine whether discretion should be denied here. Another thing I want to touch on briefly are motions to amend. You heard Mr. Mao say earlier today that there were very specific rules for amending claims in invalidation proceedings in China, and the U.S. has similar rules as well. Generally speaking, you're allowed one motion to amend your patent claims in an IPR, although there is a pilot program right now that would allow you to file a revised motion if you get permission from the board. And these motions are rather restrictive. It's presumed that you get a one-to-one substitution of claims. So, for example, if I want to amend my patent, I can't add in 50 new claims and hope that something would stick. This was something that was done very commonly in reexamination proceedings years ago, and one of the concerns with IPRs that people had was that patent owners would do the same thing. I walk into a reexamination with a patent with 10 claims, and I come out with a patent with 200. And so there are specific rules for IPRs that prevent patent owners from doing that. You cannot broaden or enlarge the scope of your patent claims in an IPR. You can narrow them to make things a little bit easier to get around the prior art, but you really are not supposed to be getting new patent scope. And finally, it's the burden of the patent owner to show that your new amended claims are going to be patentable over the prior art. I'd like to finish off very quickly with some general tips for IPRs that we've assembled over the years. The most important one is pick your arguments carefully. Don't make every argument that you have available to you. It's far better to have a very strong petition of one or two arguments than to have a petition that's a little watered down with 5 or 6. The board is not going to take kindly to that. They want to see what your silver bullet is. They want to see what your best arguments are. And as Mr. Nath mentioned, you only get 14,000 words in the petition, and those words get eaten up pretty quickly. Another piece of advice is not to allow the district court case to advance too far along. Yes, you have the 1-year window after you've been served with a complaint to file IPRs, but you shouldn't necessarily feel like you need to use every single day of that. As I mentioned in the FinTev and the NHK cases just a bit ago, the board will often use its discretion to deny IPRs if a district court case gets sufficiently advanced. And if you're in a jurisdiction in the U.S. like the Eastern District of Texas that moves very quickly, you want to make sure that you're not sitting on your rights and waiting until the last minute to file your IPRs. Another piece of advice is that your expert declaration that you submit with your petition, and yes, we strongly suggest that you do that, it shouldn't just parrot the same words used in the petition. And that's something that we're tempted to do a lot of the time. But really work with your expert to round out the arguments, to add additional detail, to really go deeper into things. You don't have a word limit with your expert declaration like you do with the petition. And so it makes sense to give additional rationale, additional details, and a lot more points in your expert declaration rather than just copying and pasting the petition and having an expert sign it. Finally, visuals are very powerful and very important. The visual here on this slide is from a petition that we filed some time ago, and it was a very complicated claim for a video card, a video graphics processor. And it had many limitations that were spread out all over the place. So one of the things that we did was to point out in the prior art where each of the claimed elements were in the figures. And that visual alone, it took up maybe half a page, but it really went a long way in showing the board these are our arguments, and this is where you can find things very clearly. And with that, I want to thank you all for your attention, and if you have questions now, we will be very happy to answer them. So thank you very much. Back to you, Jing.
Thank you, Brian. So thank you, everyone, for being with us for this webinar. Before we close out today, Gary, I would like to ask you, after you have heard what Mr. Mao has presented on the Chinese rules and knowing what you know about U.S. IPR, do you have any practical advice you can give to the attendees today?
Sure, Jing. I think the one thing I would stress is, if you're doing your business and if you have a competitor and you're entering a new area or you're introducing a new product and you know of patents out there, don't just wait to be sued in court in China or the United States. You should look at the various options available to you. How can you choose to attack patents maybe even before you start selling your product? What available options do you have in China? What available options do you have in the United States? What if you're sued in the United States? What if you're sued in China? How can you put yourself in the best position to defend a lawsuit? Will it help you to launch one of these proceedings in China or the United States before you're even sued, to proactively take the initiative and attack the patents? And there's a lot that you can do ahead of time in order to put yourself in the best position to be able to sell and market your product, because of course that's the bottom line. To promote your business, to compete in the marketplace, and to avoid claims of patent infringement, or if you're sued for patent infringement, put yourself in the best possible position to win. So I would suggest that companies look at what patents are out there, think about what patents might be potential blocks to selling their products, and then sit down with qualified counsel and put together a team of excellent U.S. and Chinese attorneys, figure out what your options are, develop a strategy, think ahead, be proactive, and take advantage of the various procedures that we've discussed today, which may allow you to kill patents before you even end up in an infringement lawsuit. So that would be my suggestion.
Okay, thank you so much, Gary. That marks the end of today's program. And if you have any additional questions, please do not hesitate to reach out to us. Thank you, everyone. Bye.